The parties in the case of the New York Times Company versus Sullivan are the plaintiff, L.B. Sullivan, the Montgomery City Police Commissioner, and the defendant, the New York Times Company. The facts that led to their dispute was the publication of a full-page ad by the New York Times which alleged that the arrest of the Reverend Martin Luther King Jr. for perjury in Alabama was done to ruin his campaign efforts in integrating public facilities and to encourage African Americans to vote. L.B. Sullivan had filed a libel action against the newspaper and 4 black ministers who had endorsed the New York Times ad, in which Sullivan claimed that the allegations against the Montgomery police was a direct slander at him personally. Sullivan felt his reputation was damaged by the New York Times publication because some of the information that was provided in the ad was false, and these false claims referred to him directly because he had oversight responsibility of the Montgomery police. The advertisement was titled "Heed Their Rising Voice," which stated that the police had committed unjust violence and terror on the students of Alabama State College and others who participated in the civil rights movement in the South. The New York Times had depicted explicit detail of the actions taken by the police, which one paragraph in the ad stated, intimidation and violence, by bombing Martin Luther King's home while King's wife and children were present, assaulting and charging him with perjury. The ad also depicted how the police padlocked the dining hall at the Alabama State College campus, resulting in starving students into submission to police authority. Elements of defamation are: the plaintiff must prove that the defendant made defamatory or false statements about the plaintiff. The plaintiff must prove that the defendant published this information without the plaintiff's consent. The plaintiff must prove that the defendant acted negligently in publishing these statements. In some cases, the plaintiff must provide proof of damage that the statements that were published had actual malice, and that these false statements caused specific damage. Also, in order for a statement to be deemed defamatory, like Sullivan, the plaintiff must prove that statements made were made with knowledge of its falsity or with reckless disregard of whether they are true or false, on the grounds that the statements must concern an issue of public or general interest. The Supreme Court's decision in this case was reversed and remanded. The court made the decision because the First Amendment protects the publication of all statements, even false ones, about the conduct of public officials except when statements are made with actual malice. The parties in the case of Gertz v. Welch are the petitioner, Elmer Gertz, and the respondent, Robert Welch, Inc. The petitioner was a private figure. The alleged defamatory statements about Gertz in the article from American Opinion labeled him as a communist fronter and a Leninist because he was hired by a family to sue a Chicago policeman named Richard Nuccio who had killed the family's son. The article headed, "Frame Up, Richard Nuccio and the War on Police," in the magazine because Gertz chose to represent clients who were suing a law enforcement officer. The article was published alleging that Nuccio's murder trial was part of a communist conspiracy to discredit local police. This article had falsely stated that Gertz had arranged Nuccio's frame-up and made implications that Gertz had a criminal record. The article also stated that Gertz was an official of the Marxist League for Industrial Democracy, originally known as the Intercollegiate Socialist Society. This organization had advocated the violent seizure of the United States government. Gertz had also been an officer of the National Lawyers Guild, described in the article to be a communist organization that probably did more than any other outfit to plan the communist attack on the Chicago police during the 1968 Democratic Convention. The statements made were found to have inaccuracies. First being that Gertz was accused of having a criminal record. There was no evidence found that he had or held a criminal record. It was proven that Gertz was a member and officer of the National Lawyers Guild 15 years prior, but no evidence could be found that the organization or he had any part in planning the 1968 demonstrations in Chicago. Also, there was no basis for the charge that Gertz was a Leninist or a communist fronter. Finally, he had never been a member of the Marxist League for Industrial Democracy or the Intercollegiate Socialist Society. After these accusations were made, the managing editor of the American Opinion made no effort to fact-check this information. He instead gave out a statement saying that the author had conducted extensive research into the Richard Nuccio case. The 1970s were the height of the Red Scare, and many Americans believed much of the propaganda that circulated around the country concerning communism. After this article was published, many citizens believed the claims and accusations that were presented, which led Gert's reputation to become tarnished as both a lawyer and American citizen. By human nature, first opinion often leaves lasting impressions. I would have done extensive research on the accusations made about Gertz in the article before I would have allowed it to be published for public audience. Once I had found no solid ground or basis for these accusations, I wouldn't have allowed the story to be published, knowing that this could have lasting consequences for both myself and the subject. I also would have found a different pitch to tell this story. Make it an opinion piece about the Nuccio case through the facts to support the opinion I am expressing instead of focusing on Gertz. New York State's elements of defamation law according to the Digital Media Law Project are 1. False statements, 2. Published to a third party without privilege or authorization, 3. Fault amounting to at least negligence, 4. The caused special harm, or defamation per se. Defamation, when it comes to both public and private figures, strongly depends on the vortex notion of a limited purpose public figure. These are individuals who have thrust themselves to the forefront of a particular controversy in order to influence the resolution of these issues involved. When a plaintiff is a private figure and the statements made are defamatory relate to the matter of a public interest and are of a legitimate concern, the plaintiff must prove that the defendant acted in a grossly irresponsible manner due to consideration for the standards of information gathering and dissemination ordinarily followed by responsible parties. The state of New York courts also recognizes privileges and defenses in regard to defamation. This includes fair report privilege, in which speakers cannot be held liable for giving a fair and true report of any judicial proceeding, legislative proceeding, or other official proceeding. Also included are the opinion and fair comment privileges, substantial truth, and the wire service defense. Under this defense, the court will not hold republishers liable for reproducing defamatory content unless the republisher had or should have had substantial reasons to question the content's accuracy or the original speaker's good faith and reporting practices. Statute of limitations for defamation in New York State has adopted the single publication rule. The rule applies to the Internet, with the statute of limitations running from the time the defamatory content first appears online. Republication of defamatory content will restart the statute of limitation, and this occurs when a separate aggregate publication from the original on a different occasion, which is not merely a delayed circulation of the original edition. I can relate what I've learned from the Sullivan and Gertz cases to my future work in the communications industry, is that, as a journalist, I must always be conducting extensive and in-depth research on any individual or topic I wish to write, talk, and publish about. If my information is not accurate, not only does this affect the reputations of the subject matter, but also as myself as a journalist. It is key to be most accurate with the information I wish to share with my audience.